We're moving on now to Fernando. Fernando has given us presentations in previous years. We're running really late now, so I think perhaps we might just. Do you want me to do a full introduction, Fernando, or would you like to?
No, you don't. You don't have to
Everyone's
say
got the written
anything.
program, so we
You don't
can
have
go.
to say anything about me. And I will try. And I will try to keep time. I mean, do you
Don't,
see my screen?
we do see your screen, but
Do
it's
you see the
yes. Now we've got it
presentation?
full.
Okay. Well, there's too much information there, but it stands for your. Let's say that it stands for your introduction, Shannon. No need to say more. So today I will first discuss how the situation of locked-in persons has been understood in the legal framework. And second, I will ask whether the courts, or the courts of justice, understanding of the locked-in state and the connotations of the very idea of locked-in correspond to the experience of persons living in that state. My talk is based on two articles. They are available online, but I'd be very happy to send them directly to anyone. Just email me to the address that appears there. And I'm very happy to say that one of the articles was written by my wonderful Japanese colleagues and also Catalan colleague, and that Yukiko Jimena, one of the co-authors, is here or was here a few minutes ago. So, but before I go into the topic, I'd like to make some considerations on terminology. Specialists have long used the term locked-in state interchangeably with locked-in syndrome. More recently, locked-in state has become common in connection with clinical situations that arise in the late stages of ALS. But there are no norms or fixed usage. So, for example, some authors speak of some advanced ALS patients as being incompletely locked-in syndrome, while others describe them in the totally locked-in state. What is there in these terms? Locked-in syndrome was introduced in 1966 by the neurologist Fred Plum and Jerome Posner in their seminal textbook, The Diagnosis of Stupor and Coma. Its creation was part of an effort to avoid misdiagnosis, a topic that is obviously still extremely important, as we heard before. In particular, the confusion between the form of coma known as akinetic mutism and the condition they named locked-in syndrome. Plum and Posner defined this syndrome as a constellation, I quote, a constellation of alert wakefulness accompanied by mute tetraplegia of brainstem origin. So Plum and Posner limited the term locked-in syndrome to a condition resulting from brainstem stroke. Because of clinical similarities, the term was later applied to the locked-in state due to ALS. But today we seem to have returned to the more specific original usage. The expression locked-in state has become preferable to locked-in syndrome when referring to persons with advanced ALS who can no longer articulate speech. Thus, the most recent overviews of the locked-in syndrome do not include ALS among its causes. Do not include ALS among its causes. And the most recent editions of Plum and Posner speak of the locked-in syndrome under the heading locked-in state. So in conclusion, individuals with advanced ALS may enter the locked-in state, but they won't be diagnosed with locked-in syndrome. In contrast, a person who is locked in due to a brainstem stroke is diagnosed with a locked-in syndrome, but is also obviously in the locked-in state. We'll see that these distinctions, however, are not merely about names. Now let's move on to the question of legal rights and communicative capacity. The situation of persons diagnosed with locked-in syndrome, with LiS, I will say, raises a significant legal challenge. As a consequence of a brainstem stroke, they are quadriplegic and lack articulate speech, but have normal visual perception, bodily sensations, consciousness, and cognitive functions. With assistance, they can communicate, express their will, make responsible decisions, and exert their civil rights. There seems in principle to be no reason for restricting their legal capacity. This, however, has not always been recognized. In the early 2000s in Spain, Charlie and Mauricio, two men with LiS, were declared incapable. Incapable was the name for the legal status that deprived them of a number of civil rights, including the right to vote, to make a will, or to manage their assets. Both appealed to that decision. Charlie and Puri and his wife Puri have been collaborating with our project for a long time, and these are their real names, which I use with their permission. Mauricio also worked with us until he passed away in 2019, and Mauricio is the name he's given in the publicly available legal records. It's a pseudonym. I'm deeply grateful to them and their families and partners for their collaboration with our project. With regard to their cases, I'm interested in what justified the legal decisions. Declaring Charlie and Mauricio incapable was obviously unfair. Persons in classical and incomplete LiS as they were depend on others and on various devices to communicate and satisfy daily practical needs, but their mental capacities are intact. The judge's decision was not based on a cognitive assessment, but on what their mode of communication seemed to reveal about what the Spanish Civil Code described as the capacity to govern oneself. This autonomous self-governance, and therefore legal capacity would be preserved as the locked-in person did not depend on another human to communicate. Thus, if you used an alphabetical board and therefore depended on a human mediator, then you will be seen as having lost the capacity for self-governance. But if you communicated using a computer by yourself, you were judged autonomous and legal capacity was preserved. I find it absolutely fascinating that only the human-machine system was trusted to convey reliably an individual's autonomous will. And we shall later discuss the assumptions about normality and self-governance implicit in the rulings. Now let's focus on the cases. In July 1999, at age 33 and just married, Charlie suffered a stroke that left him locked in. In June 2000, a year later, a court considered that his lack of mobility and inability to communicate verbally and by himself demonstrated that he lacked this self-governing capacity in the personal and financial sphere and appointed his wife as guardian. Not long afterwards, Charlie chose to move to a residential home for dependent elderly persons. There, as he tells in a memoir published in 2005, he realized that although a good number of residents were affected with dementia, only 3, including himself, had been legally incapacitated. Some of those residents' voting bulletin had been even filled in by relatives. He was sure about that because he had witnessed it. So this prompted him to fight to get back his civil rights. In 2005, Charlie's wife requested the reintegration of his legal capacity.
Fernando, sorry to interrupt for just one moment. I'm not sure whether your slides are showing. We've still got table 1.
No, I'm not showing anything.
Okay.
It's just there. I have very few slides. I don't have any slide for what I'm telling right now. So the court, to which he then appealed, observed that what Charlie depended on others for instrumental activity, what they called instrumental activities, I could therefore not exert what is termed self-care. His cognitive and volitional functions were fully preserved. Moreover, he could communicate by means of a computer or blinking. Thus, the judges concluded that his limitations regarded only self-care and the material execution of some acts, and moved him to a regime of partial capacity, thus explicitly returning to him the right to vote and to make a will. Mauricio's case was more complicated. In 1994, a stroke left him locked in at the age of 50. He was juridically incapacitated in 1997, and that decision was confirmed by a higher court in 1999. In 2004, the Spanish Supreme Court rejected a new appeal, but 5 years later, a lower court reinstated his legal capacity. And the legal documents show that the ultimate ground for all juridical decisions had to do only with the way he communicated. As one of the rulings explained, I quote, "The core issue is whether the illness or physical disability suffered by the defendant is sufficient cause to incapacitate him, regardless of the fact that he returns his cognitive and volitional faculties." It is repeatedly noted that Mauricio's condition, mistakenly described as aphasia, prevents him, I quote, "from freely expressing his will." This observation comes from the report by a forensic doctor who also highlighted that Mauricio's higher mental functions were preserved. At the trial that incapacitated him, the nurse who took care of Mauricio demonstrated the use of the alphabetical board. Showing it to Mauricio, I quote from the ruling, the nurse asks him if he wants to say something and slowly points to each letter with a pen. Mr. Mauricio chooses the letter by nodding his head and moving his eyes up and down. The nurse then writes down the chosen letter in a notebook and points to the letter again until Mr. Mauricio chooses the next one, writes it down again, and so on until what Mauricio wants to say is complete. In this case, the sentence formed is, "Today is Thursday." The situation in which the nurse approached Mauricio with the board and thus initiated the exchange supported the judge's argument that, as they put it, this form of communication is not spontaneous. It does not occur at the request of the patient, but at the request of third parties. Passivity and lack of agency were recurrently emphasized. Thus, the court wrote, Mauricio's condition, and I quote again, prevents him from communicating freely and spontaneously with the outside world. The precarious means of communication he uses may be sufficient for his relationship with the people around him who are responsible for his care, but it is not sufficient for normal communication with the outside world that would enable him to manage his person and property. This form of communication is not spontaneous. It does not occur at his request, but at the request of third parties. Of course, these observations point to real limitations on Mauricio's part. The board indeed has to be held by a mediator who converted his blinkings into words and sentences. The question is whether such circumstances warranted the conclusion that Mauricio, I quote, lacked the freedom to implement the decision he has previously made, both with regard to himself and to the administration of his assets. With appropriate assistance, Mauricio was able to communicate any decision he might have made with his perfectly clear mind. However, the ruling suggests that freedom meant not needing another human being's help or any form of human mediation. Autonomy in the sense of total self-reliance was thus seen as a condition for what the judges described as normal communication with the outside world. Within such understanding of freedom and normalcy, the courts could only rule that Mauricio was incapable and maintain him under guardianship. What determined Mauricio's recovery of legal capacity in 2009 was not a change in cognitive status, but his ability to use a tool that, as his lawyers argued, allowed him to communicate without anyone else's help. While, as acknowledged by the court, Mauricio's condition had not changed, he had in the meantime acquired a computer with an eye tracking system. As the judges put it, that now enabled him to express his will and execute all decisions, except obviously those related to his physical activity, in an autonomous manner without anyone's mediation, involvement, intervention, or help. This included the management of his assets like banking, shopping, and so forth. The conclusion was that Mauricio's eye tracking and computer system, I quote, substituted the capacity of expression of verbal language and its graphic representation, enable him to engage in normal communication with his surroundings, which grants him almost full autonomy in his daily life. Again, we see here implicit notions about normality. Modern legal systems require not only proof of cognitive and volitional capacity, but also the subject's ability to express or externalize their will and choices in a verifiable manner. Depending on a human third party for communication raises three interconnected issues: authenticity, or how to determine that the transmitted will is truly the subject's; trust, or how to be sure that the mediator does not influence, distort, or manipulate the subject's message; and verification, or how can the courts or anybody else independently establish the accuracy of the transmitted message. These are not simple issues, and experience shows that there are good reasons to distrust or at least be very cautious about communication mediators and facilitators. An individual's ability to externalize their will without human help raises doubts about their autonomy, which is a central feature of legal personhood in the Western liberal tradition. The end result in our cases was that machine-supported communication preserved legal capacity, but active relationality did not. In a broad perspective, this reflects the fact that our legal systems still assume the individualistic notion of autonomy and the person that emerged in early modern European philosophy and political theory in the late 17th century. In spite of appearances, this also applies to the Convention on the Right of Persons with Disabilities, or CRPD, adopted by the United Nations in 2006. Its assertion of legal capacity as an inalienable human right, regardless of actual physical or mental capacities, perpetuates the individualistic notion of the person. In countries that have incorporated the Convention into their civil codes, Cases like those of Charlie or Mauricio have less chances of arising, not because the legal system has adopted a more relational view of the self, but because legislation reinforced and expanded individual rights. Replacing substitute decision-making regimes by support regimes reinforces individual autonomy as understood for subjects who would be independently from anything different from or beyond themselves. Although the Spanish Civil Code integrated the UN Convention in 2021 and eliminated incapacity, the cases of Charlie and Mauricio are not merely historical. Indeed, many countries, including in Europe, envisage substituted decision-making regimes and keep incapacity in their civil codes. Beyond the principles such as equality before the law, what are the problems revealed by the cases we sketched? First, they reveal the harmful effects of the law's systemic distrust of human mediators. Courts privilege normal, so-called normal, and mediated communication over clear evidence of intact cognitive and volitional capacities, even though these are considered the defining features of legal personhood. If mental capacity is intact, legal capacity should follow, regardless of physical impairment or communicative dependence. Safeguards could have been implemented to verify the accuracy of mediated communication. Because such safeguards were neither required nor customary, the default solution was to deprive individuals of their rights. This was not only inconsistent but unfair. Guardianship, which is intended to protect, in this case negated civil liberties and violated the presumption of capacity, something especially egregious in the case of cognitively intact individuals. Second, even reforms promoting supported decision-making retain an individualistic mode of legal personhood. An alternative would recognize human beings as inherently interdependent and admit that relationality is not incompatible with autonomy. Third, judges trusted high-tech devices such as computer or eye-tracking systems while distrusting low-tech mechanisms such as blinking with an alphabetical board. But this is paradoxical. On the one hand, substituted decision-making itself depends on human intervention. On the other hand, high-tech systems are also human-made, require setup and calibration, and can embed biases. We know that from our phones and all sorts of algorithms that rule our lives. Low-tech systems, while mediated, can be made transparent and verifiable and may be less susceptible to distortion than predictive digital interfaces. With appropriate safeguards and interpersonal trust, they can be as reliable, if not more so, than sophisticated technologies. In the end, communication is a means of agency, but it must not be conflated with autonomy itself. Even major difficulties in expressing personal choices do not imply an inability to make them. Although technologies such as brain-computer interfaces are more complex than alphabetical boards, they too rely on human design and interpretation. Legal cultures may hesitate to trust opaque systems, and caution is warranted. Yet all communicative systems, be they low-tech or high-tech, entail human mediation and uncertainty. These uncertainties, however, exist alongside the imperative to support persons with severe communication disabilities and to recognize that communication is not merely instrumental but fundamental to being a person and part of the human community. Now, what does all this have to do with the terminological questions I discussed at the beginning? With our Japanese colleagues, we distributed a semi-structured open-ended questionnaires to persons in the locked-in state or diagnosed with locked-in syndrome in Japan. Sorry, I don't know what this is doing here. Oh, no, let's forget about that. Here, this is the article, sorry. With our Japanese colleagues, we distributed semi-structured open-ended questionnaires to persons in the locked-in state or diagnosed with locked-in syndrome in Japan, Spain, and France. Where most Japanese respondents were locked in due to ALS, most Europeans had suffered a brainstem stroke and were diagnosed with locked-in syndrome. We reported on responses to two questions. What do you think about the official name of the diagnosis, locked-in syndrome? And sometimes people with locked-in syndrome are described as a mind trapped in a body. What do you think about it? Why? We found that persons diagnosed formally with locked-in syndrome say the name corresponded to their condition. Some accepted the trapped mind image, others did or not, or only for certain circumstances. Most respondents who were locked in due to ALS rejected both the term and the image as inaccurate precisely because they could still communicate. The difference between the two groups reflects diverging illness trajectories. Those who suffered a stroke experienced a sudden entrance into the locked-in state and a period of quasi-absolute captivity from which they emerged gradually. So the idea of the locked-in makes a lot of sense for them. ALS patients, in contrast, experience the opposite, since their illness can gradually take them to an increasingly locked-in state. These results suggest the extent to which the locked-in vocabulary emphasizes the features that the persons affected are keenest to overcome and, in many cases, most capable of surmounting. Keenest to overcome because communication plays a role that is not only practical, but, as I mentioned, also existential. And most capable of surmounting because a range of technologies, from the low-tech alphabetical board to high-tech electronic devices, allows them to communicate effectively. By calling attention to the deficit, current official terminology may negatively contribute to shape self-perceptions and especially how others apprehend and understand locked-in persons. This is illustrated by the cases of Charlie and Mauricio. The possibilities that were available to them, effectively available to them as practicable outcomes, were pushed entirely into the background, negated, and denied. It might therefore be worthwhile to consider finding a vocabulary that does not symbolically seal affected persons' fate and foreclose demanding but conceivable prospects. It is true that, as this very meeting demonstrates, the locked-in terminology is well established and has proven itself in neurology and the clinic, in patients' associations and testimonies, in the media and the broader public. But locked-in persons' dissatisfaction with it suggests that we could do better. As long as the usual terminology is in place, the main practical guideline may consist of placing less emphasis on the locked-in status and vocabulary and more on what is existentially crucial for the persons affected, that is to say, the potential to communicate and the fact of not being literally and absolutely locked in.
Thank you, Fernando. That was an excellent explanation about the rights and the way that people assume that people have or have not got abilities. That's extraordinary. And it's saddening to think that it's only happening in some countries, that it's not a worldwide movement, really. Do you think that that's something that is going to be coming along as a worldwide decision-making?
I think the incorporation of the Convention on the Rights for Persons with Disabilities into legal systems helps a lot. But it's not. It is actually not enough, because some European countries have actually incorporated CRPD into their civil codes and still, however, maintain a incapacity status. So I think there's a lot to be done. I think that the most complicated thing, in a way, is to rethink some dimensions of legal personhood in order to incorporate, to make it less individualistic. Yes. And to understand that that we are all dependent, all human beings are dependent, of course, not to the same extent, not in the same domains and so on, and that should create some mechanisms for rethinking some of the legal mechanisms. I think overall it can happen, but it takes a lot of work and a lot of persistence and a lot of vigilance, because it's not enough to pass a law that looks better than the previous laws just to, as I mentioned, just make sure that the law will be applied and that there will be resources and so on.
Absolutely. Does anyone else have any questions? Stefan's waving his hand. Hello, Stefan, again.
So from what you've been saying, I'm gathering that the fact that people with locked in cannot autonomously initiate conversations has, at least in Spain, legal consequences, and that changing that may changing their ability to autonomously initiate conversation may change the way that they're supported.
That is exactly what happened. What happened in these cases? I mean, this was the past. I don't think this could happen in Spain now because the law has incorporated the convention. The state of incapacitation no longer exists, but it exists in other places. So that's why I say they are not merely historical cases. You know, there's not just interest about the past. But that's exactly right what you said. When these two locked-in persons could demonstrate that they could use by themselves a computer, basically, then they recover their civil rights because what was judged sort of unacceptable or not part of normal, so-called normal communication and so on, was the idea that they depended on another human. Now, depending on another human, I don't see as less as more deserving of distrust as depending on a machine, because behind the machine they're humans, and we are governed by all sorts of algorithms which are stuck into our machine, to the machines we use every day, by humans, and we have very good reasons. We now know perfectly well to distrust the machines that we use every day. And I don't see any more reasons to distrust, humans, direct assistance from humans, as to distrust machines. Of course, I understand there have been egregious cases of manipulation on the part of mediators and so on. So, but with appropriate safeguards, if the person needs to vote and depends on another person to communicate her vote, then, well, the judges could appoint, a third person to check that vote indeed, I mean, there are all sorts of easy safeguards, not
Yeah.
costly. And actually, the human safeguards are less costly than the machine safeguards.
You're absolutely right, Fernando. I think Stefan was particularly interested in that because his presentation that he's doing later on this afternoon is about initiating conversation and initiating
Great.
communication. So I think you'll probably both find each other's very interesting.
Excellent.
Thank you so much, Fernando. I don't think there's anybody else putting their hand up.